now having to present your value to the buyer side, the typical sales language is features and benefits of a product or a service. With a product, let's say a Procter & Gamble Tide detergent, I could demonstrate the benefits of that product to you, or Pampers diapers, or Bounty paper towels, the quicker picker upper. Easy to demonstrate the value that we have with our product. In a service, it's much more subjective, much more difficult. One of the best ways you can prove your value is past testimonials or industry awards that you've won or earned to show that you really do add value to your clients.
Great answer. Anything you want to expound on that, Doug?
No, but right in line with what Tom said, it is more difficult in a service industry to show your point of distinction and your value. We used to have a joke that if you were on trial for murder, you wanted Johnny Cochran because he was the best. Everyone knew this was the best defense attorney. But in a closing scenario, they said, well, did you get it to the table and get the money handled, the deeds recorded? It's viewed a little more in a sort of a pass-fail fungible role. So it is harder. I can find the client testimonials. I can find the things that make us distinctive and separate us. But I just had the conversation yesterday with an agent that another attorney was $100 cheaper than I am, and would I reduce my price? Wow. And years ago, when we first started, we were a little more of a Wild West, let's make a deal. Now we have what we call integrity with our fees. We have a published fee schedule, and we know, not from industry research or improper price fixing, but we know about what the market is, and we know we're very much in the middle of what the market, not the cheapest or the most expensive. And we can hold our hand up and say, we charge fair fees. They're in the range, in the middle of what most people charge. And I don't feel a compulsion to have to match every lowest price offer.
Great point. Now,
could I add
yes,
to that?
Please.
Okay. Doug's in the same situation we are with regard to competition, and a client saying, well, I have an agent who would only charge X, I want you to meet that or I'll go somewhere else. And the real challenge is to compare value between the two parties, and that's from the features and benefits. And unless you know what the other party's features and benefits are, basically, to compare with what you offer, it's difficult to reduce it to anything other than just the pure dollar value.
Great point. And that's actually what I was going to state. So that's great. I'm glad you said that. Another thing that we're hearing, and that's part of the lawsuits, I know it's in one of the lawsuits, I think it's the Merrill one, where it talks about the fact that the seller was not always very happy about, or the seller was not very happy about having to pay the buyer's agent fee. So with that being said, what do you think the ramification will be? And I see, and let me incorporate what Myrna just put in the chat, that she was always taught that if you sell on price, you'll always end up cutting price over and over again. Value is key. That's a great point, Myrna. So what are the ramifications as far as buyer's agents throwing in that value, understanding the benefit, and if NAR does end up losing, or it does go into a situation where we become sub-agents? Tom, I'll start with you. What do you think the ramification, or how will it look like, I guess, is the question.
Okay, I think history here is important. And Deborah, you may be the only one here, I don't know, the 20 plus doesn't say how much longer, but back up until the mid 1990s, if an agent was going to work with a buyer, they were still what was called a sub-agent of the seller, and their fiduciary was actually back to the seller, even though they were working with the buyer. So the seller paying both their listing fee and sub-agent fee, who was really had a fiduciary back to them, made sense. That formula was fine. But in the mid 1990s, full buyer fiduciary agency came into existence, but they never changed the compensation structure. So now you have a seller who's paying not only for their agent, they're also, in their minds, when they find out what the system is, they're paying for the other agent, and the other agent is working to negotiate against them. That doesn't make sense if you're a seller. So there's a lot of talk about decoupling the commission sharing, and that the seller side listing agent would pay the seller, and the buyer side, the buyer would pay the buyer agent. It's all kinds of complications with that because many buyers won't have the money to come out of pocket to pay their own agent. The seller pays from the proceeds from the sale of the home. So I think you'll see in most cases a complete decoupling of commission sharing, although there are some MLSs who are not NAR affiliated who have already changed their rules to allow now the buyer and the buyer's agent to negotiate the cooperative compensation as part of the terms of the purchase contract. That has never been allowed with the Code of Ethics currently in NAR. So that could be a major change, where if the listing agent is offering zero cooperative compensation, the seller is offering zero cooperative compensation, now the buyer and buyer's agent can attempt to negotiate in the terms of the purchase contract, the seller side paying something to the buyer side.
And let me state real quick, and Doug, you can expound on this, but just so you Georgia people know, that is not okay in Georgia. So in Georgia, and I see it all the time where commissions are discussed in the contract, but we are not parties to the contract. That needs to be discussed in your brokerage agreements, not in the contract, at least not in Georgia. Correct, Doug?
That's right. And that's why we have separate instructions for commissions. The obligation to pay a commission is set by a separate contractual agreement between the parties and their agents.
Thank you. And Doug, with that being said, you mentioned at the beginning that Georgia's ahead of the game, and Tom just touched on that, where some of these changes are happening. Can you elaborate a little bit on some of the changes that we've made in Georgia and other states have as well?
I think it was about 2 years ago, and it was in response to not the Burnett trial, but the Department of Justice lawsuit against NAR alleging anti-competitive practices. That in Georgia, we began to, in our buyer brokerage, disclose the price of the buyer broker fee, and did include the language that you, the buyer, are responsible for this to the extent that the seller doesn't pay for it. And that was sort of a fundamental change in the way that buyer compensation was disclosed, or buyer's agent's compensation was disclosed to the buyer. And it was ahead of the Burnett trial, and it matches up to that.
Perfect. I appreciate that. That's correct. If you guys remember, we also even added that section 4B. Those Georgia agents, we added section 4B in our brokerage agreement with the seller, where it actually says we get X amount. And you guys always hear me talk about chickens instead of amounts of money because of the Sherman antitrust. So we talk about if I'm getting 6 chickens from the seller, then 3 chickens will be given to the co-op or whatever I choose to do. Go ahead, Tom.
I just wanted to confirm, Doug, I think I've read where the Department of Justice and NAR reached an agreement on some of the changes that NAR would make because of that. But didn't the Department of Justice backtrack on that agreement?
Unfortunately, you're correct. They did. The Department of Justice started an antitrust proceedings. They reached a settlement agreement. NAR agreed to make certain changes in the way that commissions were disclosed. And really, it was sort of an unprecedented move from the Department of Justice to pull out of a settlement agreement to which they had already consented to. Mm-hmm. But they did pull back and are continuing that. Nonetheless, we did have a settlement agreement, and we did make changes in reliance on it.
Exactly. And I noticed Janine Daniel wrote, every agent I know puts the commission or compensation in the purchase and sale agreement. I'm not telling you everybody doesn't do it. I know they do it. But at least here in Georgia, if it ever gets audited, that could potentially be an issue. Because guess what, guys? You're not a party to the contract. And if it shows as an enticement, which they interpreted it as an enticement, that could be an issue. That is why we have our separate brokerage agreements. Go ahead, Tom.
Just to note, because there are some new agents on, with current code of ethics, standard of practice 3-2 says that once the offer has been submitted by the buyer side, not the contract signed, but the offer has been submitted, the listing broker cannot unilaterally go in the MLS and change the co-broke. And they would obviously probably lower it. But standard of practice 3-3 says, 3-2 notwithstanding, the listing broker and buyer broker can negotiate the co-broke after the offer has been submitted if both brokers agree to change it. So it's ethical to negotiate it outside of the purchase contract, just
Correct.
to note. Yes.
That would be in your instructions to closing as far as in Georgia. Doug, they're asking what the change in the buyer brokerage agreement in Georgia was. Can you explain on that change on page 1?
Certainly. We disclose what the fee being charged by the buyer's broker is, percentage or flat fee, whatever it is. And then we disclose that to the extent that fee is paid as a cooperative commission by the seller's broker, the buyer is relieved of making that payment, but the buyer is responsible for any difference. If they're only offering 2% compensation and your fee is 3%, the buyer is liable for the additional 1% in commission.
And guys, I'm teaching the class on Friday where we talk about that, because I noticed several of you guys are not getting those buyer brokerage agreements signed before you ever show a property. And the reason I find that many of those, and Tom, feel free to elaborate and interrupt on that. The fact is people don't understand how to sell their own value. So they don't want to lose the buyer by saying, hey, you might have to pay something. So you've got to be able to understand that it all goes back to that word, value and worth, right? So you want to be able to understand how to sell that before you ever show a property. Tom, would you like to add to that?
I agree completely. It always struck me as very odd when I got into real estate 20 years ago that on the seller side of the table, 100% of the time, the seller had to sign an exclusive listing agreement. Most brokers would not let you take an open listing agreement. So they signed that listing agreement. On the buyer side, here in Arizona, when I started in real estate, I'd say maybe 10% of buyer's agents had the buyer sign a representation agreement. And as I taught negotiation starting in 2005, what became apparent was that most buyer's agents didn't know how to persuade the buyer to sign a representation agreement. I think there are 14 states that require the buyer rep agreement to be signed at least by the time the offer is submitted to the seller side. But it's just something that most buyer's agents weren't taught on how to persuade. It wasn't an option for the seller. It was mandatory. They had to sign it or you couldn't work with them.
And in Georgia, guess what it is? Doug, you want to answer what it is in Georgia?
I'm sorry, what was the question again?
When are we supposed to have the buyer brokerage agreement signed?
If I'm thinking the right answer, I'm pulling the license law question that you always have to disclose who you represent before any offer to purchase is first made.
Before any offer.
Mm-hmm.
When do we usually do it? We send it at the offer, right? They
Right.
need to be aware at first contact who you're representing and signed by that offer, guys. So we all do that, right? So with that being said, what the other buzz I keep hearing out there is, maybe I shouldn't be a realtor because this is against NAR. What do y'all think on that comment?
It's interesting because recently Redfin and I think Remax and some other brokers have told their agents that they are no longer required to belong to NAR. And with the turmoil going on, we can try and guess what the real reasons are. It's just NAR's value has been brought into question recently. And what benefit do you get from the dues you have to pay? The challenge is that most of you pay an annual dues fee at the beginning of the year that includes what MLS, local association, and NAR dues. So they haven't figured out how to separate that. So if you're not a member of NAR, then you're not subject to their code of ethics. And if you're dealing with, if you remain a member of NAR and you're dealing with another agent who's not, what code of ethics do they follow, if any? What would you tell your client? I was always proud to say I'm a realtor. Here's our code of ethics. This is the highest standard we have of behavior in the industry. I hold myself accountable to it, and I would usually give my clients a copy and say, I want you to hold me accountable to it. And if I can't do that now, if I'm not a member of NAR, then what other standard do I use?
Right. And if you guys see, I'm going to put it in chat, competition.realtor is something that NAR has done very well about giving you additional information as to why there is benefit to being a realtor. Now, I'm not saying, we love real estate agents, we love realtors. And I know that many real estate agents are following the code of ethics without even realizing it, right? So I appreciate each and every one of y'all's, whether you're a realtor or not, but just be aware of the fact that this is happening. Don't just automatically say, I'm not going to be a realtor. Be aware of all the situations. What will be the financial investment or the financial penalties that NAR may be facing potentially, as well as these large companies, if this lawsuit goes forward, even, and actually if they lose? What either of y'all can comment on that?
And the jury, I think, Doug, the jury awarded $1.78 billion in fines to all of the defendants, across all the defendants collectively.
All the headlines I've read, they've rounded it up to 1.8 billion, and they've talked about that the judge's authority to issue what they call treble or triple damages, which would take 1.8 billion potentially to as much as 5.4 billion.
And I read in a news article yesterday that it was automatically trebled in Missouri anyway. And it was interesting because the Missouri plaintiffs totaled 500,000 sellers were party to that lawsuit. So that penalty was across 500,000 sellers. The worry is that if the other lawsuits turn out the same way and the plaintiffs win, and their damages, that other attorneys would file lawsuits on behalf of other sellers who went through the same experience in order to get the other sellers involved. And so you expand that 500,000 sellers to several million sellers, and the damages could be bankruptcy kind of damages for the companies if they had to pay it.
Wow.
Right.
Now, there's a couple questions in chat, guys. One of them, I'll start with Myrna's. Do you think buyers will sue because of lack of representation if they're not financially able to pay for the representation in the contract, assuming sellers are not offering any compensation to the buyer's agent and we don't want to work for free? What do you think, Doug?
I don't see that it giving the buyer a cause of action, a right to basically sue for their representation. I think it's going to, George is already, and I think you touched on this, caveat emptor, buyer beware state, and it's just going to further limit buyer options. But I don't see it giving rise to a cause of action to sue over it.
Great answer. What if we come across a listing with 0% co-op? Can we then negotiate the buyer's commission, but not add it in the purchase and sale agreement, and only add it in the commission agreement or instructions to closing attorney, and then revise the listing agreement? Or is that not even allowed? Do either of you all want to answer that one?
I'll
let Doug take that for Georgia.
Well, Tom, I was going to let you take a crack at it because I think you had already touched on it earlier, didn't you? My view is that everything is negotiable, and that's what we've always taught. Commissions are negotiable, whether it's buyer or seller. In a listing agreement, the seller and their agent agree what the commission is and how it's to be split. And back to Tom's comment about Code of Ethics 3.3, that the agents have the authority to negotiate commissions. So Tom, I'd like to hear your take on it.
I think is what I said before. The buyer's agent can negotiate with the listing broker for cooperative compensation. per 3-3. If they're successful, then I guess the listing broker would have to, if a listing broker is going to change the cooperative compensation, then they either have to take it out of their share or go back to the seller and ask the seller to adjust the total fee that the listing broker charged the seller. The just to make a note, in Europe, most buyers don't have the money to come out of pocket, or don't want to. And so they say, and this is all what I've read, 99% of agents in Europe are listing agents. Only 1% are buyer's agents because it's hard to get the buyers to pay. And that means basically the buyers will either try to get the listing agent to become a dual agent, in which case really neither party has representation, or they will go into the transaction as a quote unquote unrepresented buyer with no real knowledge about the legal documents and about the process and whether or not they could be taken advantage of by the seller side. So the other thing about 0% from the seller side, one of the issues is, and it was referenced in one of the comments about, we don't work for free. If we're a buyer's agent, we're not going to work for free. And the question came up, well, if you're a buyer's agent, would you sort all the listings that meet your buyer's criteria by the cooperative compensation being offered by the seller side, and then show your client those homes that offered cooperative compensation? And it's been addressed in the court proceedings that one of the changes the MLSs are supposed to make is to not allow or have the MLS have the capability of allowing an agent to sort by listings by the cooperative compensation to prevent that type of, and they're saying, right, you don't have to work for zero, but if the seller side is not offering anything, then the burden's on you, the buyer's agent, to negotiate with your buyer to get them to be responsible for your fee.
And if I could add to that, in our MLS, we actually just started disclosing what the buyer brokerage compensation is just a few years back. I think at the same time that we've made the changes on the BBA and on the exclusive listing agreement. But with that being said, one of the things that I, as a compliance broker, how I would answer that question is that, yes, we can negotiate with the other agent on our own. And like Tom said, take it out of the listing agent side if they're willing to, or go back to the seller. But the key there is that we can't entice. We can't make that agreement, they'll buy it if you do this. And either of you feel free to expand on that, but you can't say, yes, Mr. and Mrs. Seller, my buyer is willing to do this, but only if you pay me more. Because that would be that becomes the enticement.
It's interesting when you think about that. From the Northwest MLS up in the state of Washington is a non-NAR affiliated brokerage. So there's a broker owned, MLS, broker owned MLS. So they have made changes in 2022 to their agreements and documents to allow the buyer to negotiate the cooperative compensation as a term in the purchase contract.
Wow. The
logic on that is that if I'm a buyer and I've signed that buyer representation agreement that Doug talked about, where I'm the buyer's agent and said my fee is X, and if I don't get it from the seller side, then you, the buyer, will have to make up the difference and potentially the entire difference. If I'm the buyer and I realize that my buyer agent is not getting any cooperative compensation, I'm going to have to come out of pocket, either if I don't have it or I don't want to come out of pocket. If I can include that in the purchase contract terms and conditions and get the seller to agree to it, they're saying in Northwest now, in the state of Washington, that that's okay to do.
Interesting.
Legally, Doug, is there any law that would say you couldn't include that as a term?
Offhand, I don't know of a specific prohibition, but the one thing that does come to mind is Article 1 of the Code of Ethics, and that's that your obligation to the client is primary ahead of your own financial interest. And one of the Code of Ethics quiz questions we dealt with was a buyer wanted a house with a pool for his wife who had physical therapy and included swimming. and he showed all the homes that had pools that had the best commission, but didn't show ones with pools that had lower commission. And the implication was he was putting his own financial interest ahead of his client's interest in finding the right property for them.
Exactly.
And that's the thing that concerns me the most about trying to decide what properties you show your client and tying it to the compensation offered. Now, if you're negotiating, like I said, everything is negotiable. And my client would be interested in this property, but he doesn't want to pay his buyer's brokerage fee, and we need to negotiate that in.
Yeah, that's great.
I think just to add to the current MLS rule and the MLS handbook by NAR, which applies to the NAR affiliated MLSs, says the listing broker has to make an unconditional offer of cooperative compensation. So no conditions attached to it. So if that participation rule, which has been eliminated in the other MLSs that have gone ahead, if that's eliminated and the term unconditional is no longer valid, then as a negotiator, you start thinking about, well, if I'm the seller, I'm going to offer cooperative compensation. That's a value to the buyer's side. What can I ask for in return of the buyer's agent and or the buyer that would give me value or assurance or greater sense of closing probability, if you will? What things could I ask for if I'm going to offer cooperative compensation? And therefore getting into the conditional realm where you can place conditions on it. If they don't meet the conditions, and they don't get all of the fee. That very, very interesting, I think, down the road type of situation.
Yeah. And there's 3 or 4 actually really good questions. I'm going to start with Michael's question. I may have missed this, but how did the plaintiff's attorney show or prove the collusion between NAR, MLSs, and brokers?
Good question.
Either one want to care to answer that one?
Yeah.
Well, I think
Go ahead, Doug.
one of the first things they did, and you touched on it, was the obligation to provide a cooperative compensation. They said on its face, that's anti-competitive and a form of price fixing. So I think they seized on the obligation that you must offer a cooperative compensation as being a per se violation of Sherman antitrust and price fixing.
The other thing I saw as far as evidence went from the plaintiff's side was some of the training materials that different brokerages used or coaches in real estate that talk specifically about commission and how you would negotiate it and how you would take this position or that position. And they showed a video that apparently was very damaging for the defendants.
I believe it had to do with how it's split, right?
Yeah, how it's split and how firm you are, and it's not negotiable. So I know at least one brokerage has said they are ceasing all internal training until they review all of their training materials to make sure they don't have anything in there that would go against what's been discussed in the first court case.
Right. The other question that was asked, I'm actually going to go to Michael's other question, and I'm going to come back to Linda's. Could it give rise to action as a result of potential discrimination against a buyer if they can't pay a commission and an agent decides to not work with them? Good question. Doug?
We see this quite a bit on the lender side. There's two sort of ways to evaluate it. One is if it is on its face discriminatory against 7 protected classes. And typically, most things are not facially discriminatory. They are on their face neutral. But what they look at with lenders is, did it have a disparate impact on a protected class? So even if it was facially neutral, was the result, did the result show a discriminatory impact? And that's how redlining and, a lot of the discrimination against lender has been based on policies that, say a 680 credit score is the minimum. Well, that's on its face neutral, but does it have a disparate impact on a protected class?
Right. What about this one? What do you think, Tom? If NAR loses, do you think that that cost, that extra cost, will be pushed down to the realtors?
My guess is that annual dues, especially combined with, remember, NAR is a subscription-based membership organization. They rely on the membership dues. There's a lot of talk that the first of the year there will be a dramatic decrease in the number of realtors. So the dues, the total revenue for NAR will go down from the dues. They'll probably anticipate that, and it wouldn't surprise any of us, I don't think, if they saw larger annual dues from NAR, both as a result of the lower memberships as well as the potential damages. However, the damages that NAR is going to pay is still probably years down the road if it goes through the whole court system and appeals, or unless some settlement is reached before the appeal process is concluded.
Gotcha. A question that was also asked was, do we see brokerages changing their policy on dual agency? I don't know that any of us can truly answer that question, but what are your thoughts?
Isn't it more of a state issue, Doug? Whether I understand there are states that don't allow dual agency?
No, like in Georgia, it's totally legal. It just has to be disclosed. And so because of the liability, most brokerages will not allow it.
Yeah, I'm sorry. In other states, though, it is illegal to be a dual agent.
Could be, yeah.
Georgia,
I'm not
it is,
sure.
right?
What do you think, Doug, on that one?
I struggle with something like dual agency. Legal ethics have a similar provision that I can't represent two parties who have interests that might be, for example, two co-defendants, and maybe one of them's best strategy is to rat out the other, and I can't represent parties that might have competing interests. I think buyer and seller clearly have some level of competing interest. So I think there's tension from the start. And you can do it with the full disclosure and their ethical rules. I just think it's choppy waters. It's difficult to fulfill an obligation to two parties who have contradictory goals. Seller wants a maximum price and the buyer wants a minimum price.
Right. Another question mentioned here was related to Linda's earlier question. If we submit an offer on a 0% cooperative compensation, how can we prevent the seller from accepting our buyer's offer and listing agent not signing the revised commission agreement if the commission's not part of the contract? I'm going to just kind of throw in there right there. Remember, you're not a party to the contract. And if we take the time to negotiate commission and get the commission agreement signed before submitting the buyer's offer, then we are not fulfilling our fiduciary responsibilities to our buyers. I will also throw in there, in Georgia, we do not have fiduciary, only the attorneys do. We do have responsibility of honesty and ethics and diligence. But Doug, do you want to start with that one?
A couple of different thoughts. First, you're correct. The agent isn't technically a party to the contract. One thought is that the buyer wants to negotiate because the buyer signed, presumably, a buyer brokerage agreement where they've agreed to pay their agent, and they want to shift that responsibility to the seller. There are limitations on how much the seller can provide the buyer, typically set by the lender. But our GAR contract allows the buyer to use any seller-paid concessions for anything the buyer wishes that's allowed by the lender. So there's certainly a possibility that the buyer can negotiate in. Doesn't have to say it's for commission, but I want $10,000 in seller-paid compensation or seller-paid credits. And behind the scenes, it's because I owe my buyer a brokerage fee, and I'd like to build it into the purchase price.
Right.
And that's independent of the commission.
Right. Ahmed, you have your hand raised. Feel free to unmute and tell us your question or comment.
Okay. It's very interesting topic. Question is that before, I mean, if it goes to 0% commission or buyer agree to pay you commission, whatever the amount would be, isn't okay then to see the if they agree that they're going to pay 2 or 3% buyer's commission if the seller is not providing you any compensation. The question is that, is it okay for us to ask their financial strength, whether they're going to provide that kind of uh, uh, commission back to us before we show 100 properties to the buyer?
Let me make sure I understood the question. I'm going to try to elaborate.
So let me say it differently. Sometime, they agree to pay you 3%, okay? But
Who's
the
they,
at the
Who's
the
they?
buyer,
Okay.
when you have a commission agreement with the buyer, at the end of the day, buyer says, I paying so much to the property and I don't have much left, or whatever the reason they provide. Before you show the properties to them, 100 properties, sometime they go different areas. Is it okay for us to make sure that buyer has strength to pay whatever they agreed to pay on the buyer's agreement before we start working with them?
Is it okay to
Just like the lenders see their financial, that this person has a strength to pay to buy the property for the down payment or the closing cost.
Gotcha.
For
Tom?
us to make sure that we will be compensated if the seller is not providing any commission or anything from the listing side.
Gotcha. Tom?
I think it's a great question. It's like on the seller side, we want proof of funds from the buyer side, that they have at least closing cost funds, or if it's all cash, proof of funds for cash. Now you think on the buyer side, for your own protection as the buyer's agent, Ahmad's point, I need proof of funds that you have the money to put down X amount on a house, but you've got in addition to that money to pay me on deposit or wherever you have it. So that's a great point.
Yeah, and you could do that now. I mean, that I don't see anything illegal about that, Doug, right?
My only concern, and it's further down from what I know about the real estate closing transaction, is there are a lot of state and federal laws that come into, for example, checking somebody's financial resources.
Right.
Are you wanting to run, is it a credit check? Is it proof of funds? What exactly are we asking the buyer for? And then making sure that we don't run afoul of whether it's consumer disclosure about finances and so forth. I'm just concerned if it goes beyond just proof of funds, which is like Tom mentioned, customarily asked for by the seller. We open a different can of worms and make sure we don't open a whole new set of problems.
Well, I think that goes back into checking on your pre-approval and making sure your lender has the information. I don't know that I even would want the responsibility to check their finances, but I would definitely want to make sure that the lender has and taken that
So
step.
to take it one step further, just for the benefit of listeners, Doug, if the buyer had signed a buyer representation agreement saying that I will agree to pay X% to my buyer's agent, after they have gotten agreement with the seller on a purchase contract terms, the buyer turns to the buyer's agent and say, look, I'm sorry, I just don't have X%. All I can pay you is Y. I'm going to go ahead with this transaction with the seller because we've reached agreement. And if you don't like what I can pay you now reduced, isn't the buyer agent's only recourse to sue the buyer ultimately for the full amount if it's a separate contractual agreement from the purchase contract with the seller?
I would agree. The agent's remedy, or more specifically, broker's remedy, is to sue for the commission earned in accordance with the written contract. So it does sound very much like a breach of contract type agreement.
Yeah, which is not ideal.
No, for sure. There was a really good question asked by Sandra Leonard that she read something the other day about adding the buyer's agent commission to the sales price. She thought that would be against license law, unethical, illegal, something. My concern is that this whole thing is going to be a disaster. I've always thought of a sales price, including the commission or whatever it may be, like with FSBOs and buyers knowing they're trying to save on the commission. Would all prices on houses come down at all if they include one side, the listing side? What do y'all think? Let me, if you need me to here, I can, it should be there where you can read it.
Is it up
In the
above or
chat.
down below?
It was at 11:49 on the chat. I read, basically, I guess her question is, could we just add it to the, I mean, I guess, you know, and
Oh,
could it be added to, there was a couple questions, so I'm kind of combining two questions. Could it be added to the sales price? Could, you know, which my answer would be right off the bat, my concern would be the appraisal.
appraisal, right.
But is it illegal, I guess is the question.
I don't know that it's illegal, but the appraisal would be the issue if the buyer's taking a loan.
Right.
The
I
other,
Mhm,
well,
go
the
ahead.
other interesting question Sandra threw out is, do we think prices would come down if they're only including commission? And conceptually, you would think, well, yes, if we're only going to be paying a 3% seller's commission and we're no longer paying a buyer's, wouldn't prices come down 3%? Unfortunately, there's a lot more that goes into pricing than just the commission. I don't know that it would be a straight line reduction like you think that it might. Like, well, prices ought to come down 3% if that's the new norm, that's the standard. And I think there's just so much else that goes into pricing. I'm not sure that over the long haul, it might exert negative pressure on sales prices, but in the short term, I don't think it would be the one-for-one drop that you think it would be.
Yeah, Deborah's going to address this in the class on Friday.
Yeah.
Because it's interesting in the current environment, if the seller has a list price and is offering 0% cooperative compensation, the buyer's agent could go into the MLS because this listing agent is likely to say the seller's price is based on comps, what other properties sold for. If they do say that, especially, you can do this. Then you, the buyer's agent, would go into the MLS to see if those comps included cooperative compensation. If they did, and this seller is not offering cooperative compensation, you at least have a starting argument to say the price should be lower because you're basing it on the comps, and those comps had that element in the price. You don't have that element, so why should you price it that way?
Excellent.
On
Go ahead.
yesterday, I spoke with, well, one day this week, I spoke with two lenders. And unfortunately, they said that this case is opening up a whole can of worms for them also. It's going to drastically change how they do business, and adding the commission to their qualification sheet, a pre-qual sheet, is going to be difficult because depending upon the house, there may be no commission, there may be 1% commission, 2% commission, and the lender has got to indeed take some consideration for that. So it's going to put more work on them, and they're saying that this is just, it's a whole can of worms that's been opened up for them also, and nobody has really spoken on that. Thank you.
But with the buyer's agreement, we started when they started giving paying 2% instead of 3%. We were already adding that to the buyer's agreement, saying, hey, you may have to pay the difference if they don't pay. So that conversation has already been happening with buyers. And a lot of times the buyers don't even realize that they're not paying their agent. Maybe they'll become aware of it now for the lawsuit, but you have a place where you put that. It's 3% that you pay me as your buyer's agent. Usually the seller would provide it, but if not, you are responsible. You talk to them, and most of them are okay with that, because in the beginning, a lot of them are already thinking that they do pay us. It's really just sitting down and educating your buyer.
Absolutely. Absolutely. With that in mind, though, I do want to point out the question Janine just wrote. Why aren't you putting a commission on the strength of the property instead of an industry standard? Why not 2% if it's an easy client? I'm not understanding it, but go ahead, Tom.
You just said industry standard. There is
Exactly.
no industry standard. We have
That's
to eliminate that term. That's just
take that word out of your vocabulary. The same with normal, guys. That's what this whole lawsuit is about. There is no standard. You have company policies if you want that. Was that you, Janine? Were you trying to say something? Okay. But no standards. All right. Make sure you take that out of your vocabulary. With that, guys, I'm going to put in the chat. That's the link to the class I'm teaching from Rennie from Real Estate Negotiating Institute on Friday. There is still some room available. It is limited space. So please make sure you sign up. You will receive a certification if you go. There's different ways that you can do it. Tom, you want to explain it any further than?
Yeah, the class is called Unbeatable Value Proposition for Buyers Agents. It focuses on what we talked about earlier. What are the service features and the benefits of those features that you could choose from to put together your value for a buyer? We highlight 16 that you could include, including things like a buyer VIP program that not all buyers agents have, and it's your options and what you include in that. So there's a whole lot on your value proposition and how you would market yourself with this value proposition. And then we spend a lot of time talking about different options you have to charge on the buyer agent compensation, especially if the seller side is not going to offer any cooperative compensation.
Yes.
Let's see this. The certification you will get is certified home buyer specialist, CHBS, which you can use in your marketing.
Thank you so much. I know I want to respect all y'all's times. I will stick around with the two panelists if they have a few minutes. If you don't, I understand. If you want to answer any additional questions, otherwise you're free to go. I do see one quick last question from Sandra Leonard, which is how quickly, I'm sorry, let me go back here. Is it against GREC, which is Georgia Real Estate Commission license law, to add the buyer side commission to the price? I don't know, Doug, if you want to touch on that real quickly.
You know, Deborah, as the compliance person, I was hoping that you would take that one.
Yeah, go ahead.
Off the cuff, I don't think that's exactly how it's worded. I don't see that as a license law violation.
No, I was just going to say the exact same thing, but you've just got to remember, as long as you're not doing it as a condition or enticement, where that could become an issue. If you're adding it to the price and then you're also running into other issues such as appraisal and things like that. So just be careful, but that would be a case by case question, I think, in my opinion. Other than that, Myrna asked, let's see, whether it be, there's going to be 2020 form changes, lots of them. I'll be teaching on that actually in December. So yes, there's definitely going to be definite changes. You can go to Max One training for that. Janine has and then Janine, you can definitely ask Tom and Doug that whatever question, but go ahead. And Tom, go ahead.
Deborah, I just wanted to either confirm or not. Did you get CE approval for hours for this course?
Oh, yes. Thank you. Yes, we have 5 CE credits for this one. Possibly 6. I've got to work on that. For some reason, it only said 5 based on the additions, but definitely 5 credits for this, guys. So if you want to come on Friday, it's they're starting it with an introductory price. Rennie is, thanks to Tom being the founder. He gave a great price for this class. It's not going to always be this price. So take advantage of it. I do see also, will this be affecting the listing commission? Some listing agents are used to getting the whole amount because of no buyer's agent. That's a whole other class, Linda. We'll talk about that on another time. And then will we be teaching this class again? Well, as long as my panelists are available, we can certainly talk about it. Most of it was recorded. I forgot to put that recording, hit that record button at the beginning. Deborah's asking what the price is. Do you want to elaborate on the 2 price points on that class for me, Tom?
Sure. It's given as a one-day class, basically, from the hours. Our normal price for our 2 days certified negotiation expert class, which is the leading negotiation training in real estate, is $349. So one half of that would normally be $175. This is an introductory price to get it off the ground, and the introductory price is $97. So it's a good value.
Definitely. And yes, the Friday class, I am teaching a couple more. When you go to that link that I put for Friday's class, you'll see the other classes out there. But yes, as far as the other question, I saw a question. Oh, you can't add the commission to a loan. You can talk to your lenders, but that is a definite no-no. And then Janine, go ahead and explain the explanation to your earlier message, please.
Okay, basically in a nutshell, I started out from day one as a commercial broker and, well, agent, of course, then became a broker. All right, having no industry experience except on the corporate side as an officer for like big companies in the, signing on the other side. From day one, nobody had to tell me. I put the commission based on the strength of the property. In other words, if I thought it was an easy sale, I might put 8% instead of 10 because the usual in commercial is 10%. Sometimes I put 12. Also in residential, I did very little residential, but I had one property. If it's a difficult client or they're hard to get a hold of or, difficult to deal with, I put 8% on occasion on residential. If you're going to be a royal pain in my arse, then you know what? I made you pay for it. I mean, I'm just telling you, like if you refuse to repair stuff, I had this one lady who refused to repair stuff, cheap, El Cheapos. So I'm asking you, why do you guys not put it on the strength of the property, the client, as opposed to quote an industry standard? That's the way I did it from day one. And I still do it that way.
Doug, do you want to take the legal part of that one?
Well, I don't see, a legal problem with it
It's
unless, I don't see that as an issue from a legal perspective. It does tie into our conversation about showing your value. Or, for example, you told your seller, I'm going to charge you 8% instead of the standard 6%, and you can't tell them it's because it's worth it because you're going to be that big a pain to me.
Mm-hmm.
So being able to sell 8, I commend you for being able to sell 8.
Did it all day long.
Right.
The only thing I'd be concerned about that would be just fair housing could become an issue on that when you're opening your doors to fair housing.
I was always a listing broker.
Gotcha. Okay.
So I, it's like I said, I had people that were difficult. El Cheapo. I said, fine, you'll be El Cheapo. Fine. You don't, I got to show you your property 100 times because, you don't want to fix a dad blame thing. So guess what? Go ahead and pay me. And if you didn't pay me, fine. I'm an independent agent. Bye. See you. Have a nice day.
Gotcha. Tom, you want to say
and I got
something
it
on
all
that
day
one?
long.
I think Janine is pointing out that it can be situation specific, either because of the
Correct.
people involved. One of the issues in the lawsuit was that the band for listing fees was fairly narrow. And the complaint or the observation from the plaintiff's side was that it's a standard fee because you're charging that on expensive homes, if you can get away with it, as well as on less expensive homes. Logic would say, and I've been told in California, it's 4% because you're dealing with $1 million or higher sales price, and you'd be happy with that amount of money. But to show another example on Janine's principle, I was a third agent on a $1.5 million listing, and the seller said to me, "What are you going to do differently?" And I said, "I'm going to charge you a higher fee because I'm going to offer a higher co-broke to get more buyers agents to put their home on the show, this home on the show list for their buyers, and we'll get it sold that way," which we did. So situation specific, you can justify a different fee. And just for the purposes of the recording, all numbers mentioned during this recording are for example purposes only, not to indicate or imply that they're standard in any way.
Exactly.
Matthew, if you're still on, can you go ahead and elaborate on your commercial realtor comment real quick?
Yeah. Can you hear me?
Yes.
Okay. Yeah, I was just asking. I got a bunch of friends that are commercial agents, and I always talk with them. And even before this lawsuit, they were mentioning that in the commercial world, there is no MLS really, and there's no advertised commission for the buyer's broker. So they negotiated as part of the deal every time. They've been doing that always. Like that never changed. But my question is, if they are allowed to do that, and they do it by putting the commission as part of the offer in the contract. Now, if they're allowed to do that, why are the residential agents not allowed to? And I heard your thing about we're not a party to the agreement. But my two questions there is, first of all, if we're not a party, why do we have to sign the purchase and sale agreement as agents? And second of all, couldn't the GAR Forms Committee revise the contract so that we are a party to the agreement and it does have a spot for the commission that we're negotiating?
Doug, do you want to take that one real quick?
I'm not sure which string to pull first on that. The not a party to the contract, but do have, obviously a contractual interest in the property between you and your client. And for a variety of reasons, it is cleaner to keep those interests separate. Even with the change we've made 2 years ago, we've said that the seller has a contractual obligation with their agent, the buyer has a contractual obligation with their agent, and the buyer and seller have a separate contractual agreement. Now, granted, there's some overlap between there, but that was my comment earlier, that if I'm a buyer and I have a contractual obligation to pay my agent, I'd like to build in some seller paid costs that I can use to defray that expense if they're not offering cooperative compensation. So I think that you might be able to get at it maybe a little differently.
Go ahead, Tom.
My understanding of the commercial process is slightly different than residential, but maybe will change from residential to commercial. Commercial will start with what they call a letter of intent, which outlines the major terms for agreement, including the commissions. Once they agree on the letter of intent, they put it into the legal document between the two parties, buyer and seller. But in that document, they've already agreed through the letter of intent what the commissions will be paid. So I think their process is different. You'll see a lot of speculation about what's going to happen ultimately to residential real estate. Everything from there won't be many listing agents, there'll be a lot more buyer's agents and vice versa. One of your questions, Deborah, you're going to ask, what can agents do right now as we go through this very challenging time? Number one, I'd say stay away from the Facebook groups that are speculating. And rely on your broker. Your broker should be staying up to date with what's going on. They should be able to provide you guidance. If not, then think about that.
And be transparent. That's my number one. That thankfully, Georgia, we do have the forms in Georgia where we're pretty much transparent as long as you use them. If you're not using them, then you're putting yourself out there in perilous waters. I love this. I'm so thankful you guys had a lot of questions. I do want to respect our panelists' time. The recording will be on the YouTube channel on the bottom there, and perhaps Doug and Tom can sometimes go in there and maybe see if you add second questions there. They could go in there and answer them. But I would definitely say keep controlling the narrative. I saw somebody talking about getting retainer fees. Not a bad idea. And come to class Friday. You'll learn a lot more abilities, a lot of strengths that you can really expound on. And I look forward to seeing y'all next week. Those of you that I don't see this week, have a great day.